Okay, right there with you. Is this Mr. Miranda? Mr. Miranda, is that you?
Yes, ma'am.
All righty. Good afternoon. This is Judge Alyssa Perez presiding over the 210th District Court Criminal Docket for July 11, 2023. All matters being heard today are being heard in accordance with all emergency orders and directives regarding COVID-19. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll calling cause number 2023-0D00659, State of Texas versus Gabriel Miranda. May I have announcements, please?
David Vandenberg on behalf of the state.
Alex Shawala for Mr. Miranda. We're ready, Your Honor.
And Mr. Shawala, do you recognize your client who is appearing remotely from the jail annex?
I do.
And as far as you know, has your client consented to conducting this plea over Zoom rather than in person?
He has, Your Honor.
Mr. Miranda, I do in fact have a waiver of this proceeding being done in person. Are you in agreement to do this plea over Zoom?
Your Honor.
Oh, Mr. Miranda, it's kind of hard to hear you. Can you speak up, please?
Yes, Your Honor.
Okay, thank you very much. So let's get started with your plea. I need to swear you in. Would you raise your right hand, please? Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Gabriel Miranda, 11/15/1986.
Mr. Miranda, as I mentioned, I have documents from your attorney indicating that you intend to plead guilty in this case. The first document I have is State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Miranda, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Ma'am.
Mr. Miranda, I don't know why it's cutting out a little bit. Sometimes the audio or the internet is weird. Can you speak up? Did you?
Yes, ma'am.
Okay, thank you. Sorry, I got sidetracked. You recall, okay, did you sign that document?
Yes, ma'am.
Understand everything contained therein?
Yes, ma'am.
Mr. Shawala, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
I do, Judge.
Mr. Miranda, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Shawala, any reason to believe your client is not presently competent to enter his plea?
None.
Mr. Miranda, have you ever been found mentally incompetent by any court?
No.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
No.
Excuse me. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea. Sir, are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Puerto Rico.
So in this case, although you were charged, well, no, you were charged by indictment with the state jail felony offense of unauthorized use of a vehicle. Sir, to that charge, what is your plea? Guilty or not guilty?
Guilty.
Are you making your plea freely and voluntarily?
Yes, ma'am.
I will find you are making your plea freely and voluntarily. Mr. Vandenberg, would you summarize evidence, please?
Your Honor, had this case gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the day of May 2021 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Gabriel Miranda, hereinafter referred to as defendant, did then and there intentionally or knowingly operate a motor-propelled vehicle, to wit, an automobile, without the effective consent of Andrea Narvez, the owner thereof. This time, Your Honor, the state would ask that Exhibits 1 and 2 be presented in evidence.
No objection.
Dates 1 and 2 being the 3914 are admitted. What is the plea agreement?
The state would recommend the defendant be sentenced to 48 days confinement in the El Paso County Detention Facility with no period of community supervision.
Mr. Shawala, is that your understanding of the plea agreement? And I understand this is also per 1244B.
That is my understanding, Judge.
Mr. Miranda, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your plea. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled The Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights because this is a plea bargained or negotiated case. You do not have an automatic right of appeal. Mr. Miranda, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
Was signed by the court as well. So on your plea of guilty and the evidence introduced, I will accept your plea and at this time find the evidence substantiates your guilt. I will find you guilty of the offense of unauthorized use of a vehicle, and I will sentence you according to the plea agreement and in accordance with Article 1244B of the Texas Penal Code to 48 days confinement in the El Paso County Detention Facility. You will receive credit for any and all time that you have served. Is there anything further, Mr. Vandenberg?
Nothing from the state, Your Honor.
Shawala?
No, ma'am, nothing from the defense.
Thank you very much, Mr. Miranda. They may have some paper for you.
Thank you, ma'am.
Thank you, Mr. Shawala.
Thank you.
Thank you, Judge. May I be excused?
You may have a good day. Who's next?
You as well.
Mr. Gandara, Mr. Gandara's client.
Top of page 25, Judge. Annex, may we have Rojas, Oscar Rojas?
Yes, sir.
Ms. Melendez, I just sent you that plea paperwork.
Thank you, Judge.
Mhm. Mr. Rojas, is that you?
Yes, ma'am.
Okay.
Hey.
Ready, Mr. Gandara?
Very honor.
Calling cause number 2022-0D01829, State of Texas versus Oscar Rojas. May I have announcements, please?
David Vandenberg on behalf of the state is ready.
I'm Gandara for Oscar Rojas. We're ready, Your Honor.
And Mr. Gandara, is that your client, Oscar Rojas?
That is my client, yes, Your
And
Honor.
is it your understanding that he has consented to the Zoom plea rather than in person?
He has done it. We spoke about it and he signed the consent.
Beautiful. Mr. Rojas, I have you set for a plea today. Is that your understanding of what we're doing here?
Yes, ma'am.
Okay, do you also, I do have a consent form saying that you are in agreement with doing this plea over this Zoom platform rather than in person. Is that your agreement?
Yes, ma'am.
Okay, let's go ahead and get started with your plea. I need to swear you in. Raise your right hand, please. Sir, do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, ma'am.
Thank you very much. You can put your hand down. Would you please state your name and date of birth for the record?
Oscar Rojas, 8/13/59.
Mr. Rojas, as I mentioned, I did receive documentation from your attorney indicating that you intend to plead guilty in this case. The first document is marked as State's Exhibit number 1. Those are the plea papers. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Rojas, do you recall reviewing State's Exhibit number 1 with your attorney and signing that document?
Yes, ma'am.
Did you understand everything contained within that document?
Yes, ma'am.
Mr. Gandara, have you had more than 10 days to prepare a defense in this case?
Yes, Your Honor.
And did you explain the plea papers to your client?
I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his plea today?
Yes, I do, Your Honor.
Mr. Rojas, are you satisfied with your attorney's representation of you?
Yes, ma'am.
Mr. Gandara, any reason to believe your client is not presently competent to enter his plea?
None, Your Honor.
Mr. Rojas, have you ever been found mentally incompetent by any court?
No, ma'am.
Ever been examined by a doctor or psychiatrist who has found you mentally ill?
I'm in mental health right now, ma'am.
Okay, is there any condition that has been diagnosed or maybe anything else that could be affecting your ability to understand what we are doing here today?
No, ma'am.
Is that a no?
No, ma'am.
Okay, have you been able to communicate with your attorney, Mr. Gandara?
Yes, ma'am.
No, excuse me. So based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your plea, Mr. Cross. So are you a U.S. citizen?
Yes, ma'am.
Where were you born?
Right here in El Paso.
El Paso, Texas?
Yes, ma'am.
So in this case, you were charged by indictment with 2 counts of the 3rd-degree felony offense of failure to comply with sex offender duty to register.
Yes, ma'am.
As to count 1, what is your plea? Guilty or not guilty?
Guilty, ma'am.
As to count 2, what is your plea? Guilty or not guilty? As to count 2, sir, is it guilty or not guilty? Mr. Rojas, can you hear me?
Guilty, ma'am.
Okay, as to count 2, That was for count 2, right? You heard me?
Yes, ma'am.
Okay, are you making each of your pleas freely and voluntarily?
Yes, ma'am.
I will find you are making your pleas freely and voluntarily. Mr. Rojas, would you summarize the evidence, please? I mean, Mr. Rojas, Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor, had this matter gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 3rd day of March 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Oscar Rojas, hereinafter referred to as defendant, did then and there, while knowing that he was required to register under Chapter 62 of the Texas Code of Criminal Procedure because of a reportable conviction based upon indecency with a child, and after having changed his address, failed to comply with the requirement of Chapter 62 by failing to report in person to the local law enforcement authority in the municipality in which the defendant's new residence was located, namely the El Paso Police Department SORT unit, and the defendant failed to provide the law enforcement authority with proof of identity or proof of residence within the later of the 7th day after changing the address or first date that the local law enforcement authority by policy allowed the defendant to report. And is further presented that prior to the commission of the charged offense, hereinafter styled the primary offense, on the 13th day of June 2003 in cause number 2002 0D01384 in the 210th District Court of El Paso County, Texas, the defendant was finally convicted of the felony offense of burglary of habitation. And is further presented that prior to the commission of the primary offense and after the conviction in cause number 2002 0D01384 was final, the defendant committed the felony offense of sex offender's duty to register life and was finally convicted on the 1st day of August 2018 in cause number 2018 0D00914 in the 120th District Court of El Paso County, Texas. That is count 1. As for count 2, the state would have been able to prove beyond a reasonable doubt that on or about the 17th day of February 2022, anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Oscar Rojas, hereinafter referred to as defendant, did then and there, while knowing that he was required to register under Chapter 62 in the Texas Code of Criminal Procedure because of a reportable conviction based upon indecency with a child, and after having changed his address, failed to comply with the requirement of Chapter 62 by failing to report in person to the local law enforcement authority in the municipality in which the defendant's new residence was located, namely the El Paso Police Department SORT unit, and the defendant failed to provide the law enforcement authority with proof of identity or proof of residence within the later of the 7th day after changing the address or first date that the local law enforcement authority by policy allowed the defendant to report. And I am just going to leave it at that. The other prior charged offenses are the same in count 1. Those are numbers 2002 0D1, 1384, and 2018 0D00914.
You want to admit any exhibits?
Yes, Your Honor. The state would like to admit exhibits 1 and 2.
No objection, Your Honor.
States 1 and 2 being the 3914 disclosures are admitted without objection. What is the plea agreement?
The state would recommend that the defendant be sentenced to 5 years confinement in the Texas Department of Criminal Justice Correctional Institutions Division with no period of community supervision.
Mr. Gondara, is that your understanding of the plea agreement?
Yes, Your Honor.
Mr. Rojas, is that your understanding as well?
Yes, ma'am.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the one-page document entitled the Trial Court Certification of Your Right to Appeal. It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Rojas, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, ma'am.
I'm sorry?
Yes, ma'am.
Okay. Was signed by your attorney and signed by the court as well. So on your pleas of guilty and the evidence introduced, I will accept your pleas and at this time find the evidence substantiates your guilt. As to each count, I will find you guilty of failure to comply with sex offender duty to register and I will sentence you according to the plea agreement to 5 years confinement in the Texas Department of Criminal Justice in Institutional Division. The sentences will run concurrent with one another, and you will receive credit for any and all time that you have served. Is there anything further, Mr. Vandenberg?
Nothing from the state, Your Honor.
Mr. Gandara?
Nothing further, Your Honor.
Thank you very much. Good luck to you, Mr. Rojas.
Thank you.
All right, who's next?
Bottom of page 24, Judge.
Thank you, Mr. Gandara. Have a good day. If
Thank
you
you,
don't have
ma'am.
anything else.
Good afternoon to all.
Good
Who's
afternoon.
next?
Bottom of page 24, Judge. Annex, may we have Rios, Refugio Rios?
Which one is this?
Bottom of page 24, Rios, Refugio.
Okay, so this is not a plea.
I don't think we have any other pleas. I'm not sure.
I have one for Mendez.
Oh, that's right. We do have that one. Okay, let's take care of this one, I guess. Go ahead.
In cause number 2016-0D04953, State of Texas versus Refugio Rios Jr. Announcement of council, please.
David Vandenberg on behalf of the state.
Oh, I'm sorry, Mr. Marufo, we don't have a Rios on our list. Let me look him up, see if he's here.
Okay,
SO number for you. 243289.
He's at the downtown jail.
okay, Annex, if we could have Jesus Antonio Mendez, Ms. Chavez will come back to you. Thank you.
Yeah, yes, he's here, Your Honor. He's coming up.
Thank you. Mr. Huffman, this one's yours?
Can I ask a question? Is that Refugio Rios that you just called?
We did, Paris, but the Annex doesn't have him. He's at the downtown jail and they're not logged in yet.
Okay, so I'm here.
Oh, thank you.
And Mr. Mendez is mine, Your Honor.
Correct. So let's get started. Calling cause number 2022-0D05097, State of Texas versus Jesus Antonio Mendez Jr. May I have announcements, please?
David Vandenberg on behalf of the state, and the state's ready.
Rick Huffman on behalf of Mr. Mendez, we're ready.
Mr. Huffman, do you recognize your client from the jail annex?
Yes, Your Honor.
Mr. Mendez, I have you scheduled today for a final hearing plea deadline, but I did receive plea paperwork. Is that what you understand we're doing today, a plea?
Yes, ma'am. Yes, my honor.
Okay, so I also had a consent form to do this on Zoom. Are you in agreement with conducting this plea proceeding via Zoom?
Yes, my honor.
Huffman, you are also in agreement?
Yes, Your Honor.
Okay, Mr. Mendez, in order to get started, I need to swear you in. Raise your right hand, please. So do you swear or affirm that any testimony you provide will be the truth and the whole truth?
Yes, my honor.
Thank you very much. You can put your hand down. Please tell me your name and date of birth for the record.
My name is Jesus Antonio Mendez Jr. My birthday is 10/08/2002.
Mr. Mendez, I did receive paperwork. The first document is marked as State's Exhibit Number 1. Those are the plea papers in this case. Within that document, you're guaranteed certain rights, including the right to remain silent, the right to trial by jury, the right to counsel, the right to confront and cross-examine witnesses, and the right to call witnesses on your behalf and in your defense. Mr. Mendez, do you recall reviewing State's Exhibit Number 1 with your attorney and signing that document?
Yes, my honor.
Did you understand everything contained within that document?
Yes, my honor.
Mr. Huffman, have you had more than 10 days to prepare a defense in this case?
Yes, I have, Your Honor.
And did you explain the plea papers to your client?
Yes, I did.
Do you believe he has understood the admonishments, rights, and consequences of giving up these rights by entering his pleas today?
Yes, Your Honor.
Mr. Mendez, are you satisfied with your attorney's representation of you?
Yes, ma'am. Of course. Yes, my honor.
Mr. Huffman, any reason to believe your client is not presently competent to enter his plea?
No, Your Honor.
Mr. Mendez, have you ever been found mentally incompetent by any court?
No, ma'am. No, my honor.
Have you ever been examined by a doctor or psychiatrist who has found you mentally ill?
No, my honor.
So, based on your testimony, your attorney's representations, and my observations of you, I'm going to find that you are competent to enter your pleas today. Mr. Mendez, are you a U.S. citizen?
Yes, my honor.
Where were you born?
I was born here in El Paso, Texas, my honor.
Okay, so in this case, you were charged with 3 counts of aggravated assault with a deadly weapon. As to count 1, what is your plea? Guilty or not guilty?
Guilty, my honor.
Yeah, as to count 2, guilty or not guilty?
Guilty, my honor.
And as to count 3, guilty or not guilty?
Guilty, my honor.
Okay. Are you making each of your pleas freely and voluntarily?
Yes, my honor.
I will find you are making your pleas freely and voluntarily. Mr. Vandenberg, would you summarize the evidence, please?
Yes, Your Honor. Had this matter gone to trial, the state would have been able to prove beyond a reasonable doubt that on or about the 9th day of November 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Jesus Antonio Jr. Mendez, hereinafter referred to as defendant, did then and there intentionally or knowingly threaten Bianca Espinoza with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a firearm. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a firearm, during the commission of an immediate flight from said offense. That's count 1. On count 2, the state would have been able to prove beyond a reasonable doubt that on or about the 9th day of November 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Jesus Antonio Jr. Mendez, hereinafter referred to as defendant, did then and there intentionally or knowingly threaten Yvette Espinoza with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a firearm. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a firearm, during the commission of an immediate flight from said offense. And as to the final and third count, the state would have been able to prove on or about the 9th day of November 2022 and anterior to the presentment of this indictment in the county of El Paso in the state of Texas, Jesus Antonio Jr. Mendez, hereinafter referred to as defendant, did then and there intentionally or knowingly threaten Jesus Espinoza with imminent bodily injury, and did then and there use or exhibit a deadly weapon during the commission of said assault, to wit, a firearm. And it is further presented that the said defendant used and exhibited a deadly weapon, to wit, a firearm, during the commission of an immediate flight from said offense. That is the end of the statement, Your Honor. And the state would like to request that their exhibits number 1 and 2 be admitted, Your Honor.
No objection.
States 1 and 2 are admitted, 2 being the 3914 disclosures. What is the plea agreement? What is the plea agreement?
Sorry, Your Honor, I didn't hear that. The state would recommend that the defendant be sentenced as follows: to 6 years community supervision under the deferred adjudication provisions of the Texas Code of Criminal Procedure. The defendant be assessed a fine in the amount of $2,000 with $1,000 probated, payable immediately or in equal monthly installments throughout the term of community supervision of this cause. Additionally, the state recommends imposition of all the standard terms and conditions of community supervision, as well as the following conditions: that the defendant perform 250 hours of community service prorated monthly as a condition of community supervision, that he would be enrolled in TAP, be subject to UAs and BAs, curfew, and no contact with the complaining witnesses or the incident location, and he possessed no weapons, and there be a deadly weapon finding. That is the end, Your Honor.
Mr. Huffman, is that your understanding of the plea agreement?
Yes, Your Honor.
And Mr. Mendez, is that your understanding as well?
Yes, my honor.
Understand that the plea agreement is not binding on the court. However, if I were to reject it, I would allow you to withdraw your pleas. If I follow the plea agreement, you may not appeal this case except on matters raised by written motion and ruled on before trial or by permission of the court. The next document I'm going to ask you about is the 1-page document entitled "The Trial Court Certification of Your Right to Appeal." It is a document that explains your appeal rights. Because this is a plea bargained or negotiated case, you do not have an automatic right of appeal. Mr. Mendez, do you recall reviewing the trial court certification with your attorney and signing that document?
Yes, my honor.
Finally, the motion for deferred adjudication. Mr. Mendez, do you recall reviewing the motion for deferred adjudication with your attorney and signing that document?
Yes, my honor.
Mr. Huffman, do you discuss with your client both the benefits and detriments of deferred adjudication?
Yes, I did, Your Honor.
Mr. Mendez, do you understand that if you violate a condition of deferred adjudication, the court can proceed to sentence you up to the full range of punishment for these offenses? That's anywhere between 2 and 20 years in prison. Do you understand that?
Yes, my honor.
and a fine up to $10,000. Do you understand? If you're not in compliance, the court can do that. Do you understand?
Yes, my honor.
Okay, are you asking the court to grant you deferred adjudication?
Yes, my honor.
I will find that there is sufficient evidence to substantiate findings of guilt in this case. However, I will not enter findings of guilt at this time. Instead, I will defer further proceedings and place you on deferred adjudication pursuant to the plea agreement for a period of 6 years. There will be a $2,000 fine. All of that is going to be probated due to your indigency, which means that as long as you are doing what you're supposed to be doing on probation, you will not owe the fine. If you start messing up, failing to report, and not being in compliance, they can collect the entire $2,000. Do you understand that?
Yes, my honor.
250 hours of community service, screen for tap, urine and breath analysis, curfew from 9 p.m. to 6 a.m. unless you are working or going to school. You are to have no contact with the complaining witnesses. There will be a deadly weapon finding in this case. You are to possess no weapons or ammunition. Do we have co-defendants in this case?
No, Your Honor.
Okay. Mr. Mendez, I was just looking at your history here as we were going through this plea, and you're a fairly young man. I hope this was only, and the only time when you're going to misjudge in a way that you did in this case, right?
No,
I
yes,
want you to be compliant on your probation. I don't want you to have any other issues, because if you have any issues on probation, you're going to be exactly where you are right now. Do you understand?
no, yes, ma'am. Yes, my honor.
Okay. Alrighty. Anything further, Mr. Vandenberg?
Nothing from the state, Your Honor.
Mr. Huffman?
We would respectfully request the court consider a low probation fee due to my client's indigency.
His probation fees will be $25 a month.
And Judge, at some point, Mr.
Mendez?
Sorry, yes, sir. Mr. Mendez might want to consider moving out of El Paso to Midland, but we will address that with the court if that
Mr.
happens.
Mendez, know that you have to be here in El Paso, but there is a process. When you get established with probation, inquire, ask about all that process, and make sure if that's what you intend to do, whether it's Midland or somewhere else, that you follow the instructions that they give you if you decide you want to go. There is a process. You don't just leave on your own, okay?
Yes, my honor.
Okay. Anything else?
Nothing further.
Thank you very much. Good luck to you, Mr. Mendez.
Thank you very much, my honor. Thank you, guys. Bless you.
Who's next?
The downtown is logged in, Judge.
Go ahead.
Downtown, do you have Mr. Refugio Rios?
Yes.
Okay,
Go ahead.
in cause number 2016-0D04953, State of Texas versus Refugio Rios Jr. Announcement of council, please.
David Vandenberg on behalf of the state.
Christina Chavez for adult probation.
Mr. Harris, I can't hear you.
Turn in. Now, Robert Harris for Refugio Rios.
Is that your client, Mr. Harris?
Yes, it is.
Okay, so we are scheduled today for a probation status hearing, and I was looking at the case summary. I rarely see this on a probation case summary, but probation is in agreement with revocation with TDC.
I
So,
don't have that information. I didn't have that information.
so we have Miss Chavez. I'll let you go ahead and tell me a little bit about the summary. I usually start back to.
Yes,
most
Your
recent.
Honor. We requested an admonishment hearing and a status hearing that was supposed to be held January 26, 2023 to address Mr. Rios non-compliant with BIP, non-compliant with EHN. He didn't attend his Takumi appointment November 7th, November 17th. In January, he was admitted to the RJC program. But then after that status was held, he didn't attend a court hearing, so a bench warrant was requested. After that, he did communicate with me. I told him to go turn himself in. He had a plan to go do that. We talked about the stressors. We talked about getting him back on track. That was the plan. But when he was arrested on April 22nd, there was an offense of an aggravated assault with a deadly weapon that occurred on February 23rd, 2023 with the same victim that's on the probation case. He also picked up a resisting arrest. So the department at this point is requesting revocation.
Mr. Vandenberg, thank you, Ms. Chavez. Mr. Vandenberg, where are the cases, the ag assault, and I guess the resisting? But I'm more concerned with the ag assault.
Those are still P files, Your Honor.
Okay, can you have I don't know if are they with intake? Can you make a request from the agency if they're not with your office to have them presented to your office? Because these occurred back in February.
Yes, I saw that. They're kind of languishing here. They should have been presented by now.
Mm-hmm.
Your Honor, in terms of these cases, the state's concerned because in the new P file 2023 4354, it's the same CW. That's the basis of the primary offense here. So,
Mr. Harris, I mean, I think probation is saying they're not going to work with him anymore. And I tend to agree that in terms of, do we have an MTR
Yes, Your Honor.
or MTA?
The MTA was filed February.
February, yeah.
These did turn.
Mr. Harris,
Yes,
I've been waiting to
Yeah.
talk.
Your Honor, I
Yes.
thought all defendants had the right to have an attorney and for the attorney to be notified of any hearings or any suggestions or any letters or anything else. And not one single thing telling me that they were even asking for all these things. I'm sorry, but
What are you talking
my
about?
job is to listen, to represent my client. When they ask him to go to talk to them, I should be there.
For what are you referring to? Are you referring to court hearings or what are you talking about?
No, to all those things, they asked him to come to this hearing and he didn't show up. He didn't show up here, didn't show up there. That's what I understand her saying. Maybe I'm wrong.
I don't know if you were appointed on January 26th.
I
So
was,
Go back. Let me go back.
I might not have been appointed yet. And if I wasn't appointed,
So the application for a court-appointed attorney happened in April. So that would have been after the probation violations. I don't know that he had an attorney before that while he was on probation. So that's what I'm seeing here is that I think you were appointed. Let me see.
I've got my expert, my wife.
I'm sorry?
I've got my expert, my wife. She knows when I was appointed. I don't know any of those dates.
Well, I'm not sure I do either, but I'm trying to find them. But in any event, we have 2 new cases.
Am I a lawyer for that one, those cases also?
I don't know. Can somebody tell me about the new ag assault and the new resisting? Because he's booked on them, right?
yes, yes.
And let me go into the jailing. Maybe I can find an order appointing there.
In going over these earlier today, there's very little in these cases. They're very new.
They're not new. They're from February.
That was a horrible month for me.
Ms. Melendez, do you see an order appointing with respect to the jailing in April on that ag assault and the resisting?
I am checking, Judge. 1 moment.
Thank you. I don't see any orders appointing. But he had to have been magistrated and he qualified. I mean, they took his application and he qualified. So.
Because, Judge, I don't see them either. There's very little documents on the jailing.
Okay, so there's the warrant. This is where they booked him on the 2016 case. Here's the warrant on the 2023 case. And he requested court-appointed counsel.
And Judge, I see them on also it would be April 25th. The order of appointing attorney for Mr. Harris.
Okay, oh, there it is. Yes,
I'm calling my expert, my wife. She knows more about that than I do.
there is an order appointing you,
These are the
sir,
ones-
on the two new cases.
2 cases. And we did a motion for the.
We did a
bond.
motion to reduce. We haven't had that hearing.
Well, that one would still be in the JMAG, I would imagine, because it's not here yet. That's the whole point. The ag assault and the resisting are not, well, the resisting wouldn't be with us, but the ag assault, yes, is not
Judge,
here.
I know if it was in your court and you got the motion, you have a hearing. I mean, I can't control the magistrate's court. I can't even
Well,
talk to.
This is what I could tell you for my 2016 probation case, for which he is also booked. He's booked on the new 2023 cases as well. The DA's office needs to find out where, when are you going to present it? What are you going to do? Because as you are concerned, I am concerned too. Probation is recommending, adjudicating to just TTC, and I never hear that from probation. So it's nice, Ms. Chavez, that this rec is realistic.
Yes.
But we don't even know because we do not have the new cases that have allegedly occurred in February, and he was booked on them, arrested on them in April, and here we are in July. So where are those cases? Mr. Vandenberg, you need to find out from intake how to expedite those cases. Mr. Harris, you're appointed on them. I don't file an examining trial.
My wife agrees.
So I don't want to delay. We're just here for a probation status hearing. Mr. Harris, what you can apprise from this hearing is that the court intends to revoke him. And so we need to look at the new cases, need to give you the opportunity to do that, but we need them stat. So between the two of you, we need to have something happen so that we get an indictment if there's going to be one.
And a recommendation from the.
And a recommendation. I don't know what the facts of the new case are, Mr. Vandenberg. We're going to reset the probation status hearing for 30 days.
Yeah, in the
Solely,
new-
Mr. Harris, for both you and the state to figure out how to get those cases to my court.
Thank you, Judge. And what date is that going to be?
So that looks like August, I'll say August 15th at 3 p.m.
Thank you, Judge.
All righty. Thank you very much. Ms. Chavez, thank you very much.
Thank you, Your Honor. Maybe excused.
We're all excused. Is anyone else at the downtown facility for us today?
That's all we have, Judge.
Thank you very much. You all have a good day.
Thank you, you too,
That'd
Judge.
be excused, Judge.
You may, Mr. Harris. Good to see you.
See you in 30 days.
Okay. All right. Who's next?
Staying on page 24, Judge.
Uh-huh.
Annex, may we have Perez, Brandon Perez?
Yes, sir, he's coming up.
And as a housekeeping matter, good afternoon. I have his parents who have been trying to get into the Zoom hearing. I'm not sure if they're in the waiting room.
They are. I asked that they
Okay.
remain in the waiting room while we were conducting our other hearings, but I've let them in now.
Okay, thank you.
Are you ready to proceed?
Yes, Your Honor.
Go ahead. Mr.
What?
Maruf.
In cause number 2023 0D02878, State of Texas versus Brandon Jacob Perez. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
And good afternoon, Judge Denise Butterworth on Mr. Bettis, and we are ready to proceed.
And Mr. Pettis is appearing remotely from the jail annex. Is that your client, Ms. Butterworth?
Yes, Your Honor.
Okay, we are scheduled for both, I think, our arraignment and our bond hearing. You may proceed.
Thank you, Judge. So I just want to give a little bit of background information regarding, I assume, the bond amounts that have been allocated on my client's charges. He was originally, the date of the offense, he was originally arrested on 1 count of aggravated assault. And I guess upon some further investigation, there was an additional charge of another aggravated assault listing a separate complaining witness. And so that is why we have the 2 separate bonds that got consolidated on this particular cause number, where there are now just 2 counts. Does that make sense?
Yes, and I did review the bond order. I saw that as to count, the form itself appeared to have been amended to include count 2. So the bond, the cash surety portion was 50,000. And then I believe at the jail magistrate, as to count 2, they hand wrote 85,000, I think, on that cash surety, and the PR component remained 50,000. Is that right?
Okay. Yeah, so that's where we are right now. That was the relief initially that we were able to get from the jail magistrate, and obviously my client is still in custody. And so we come before you, Your Honor, asking for consideration for allowing him to be out on bond while we figure out how to proceed forward on his charges. My client, when he was arrested, was weeks away from graduating from high school. The high school allowed him to graduate because he had the credits necessary before he was in custody. And I want to point out to the court that this is a young kid that we're dealing with that would still be at home. That's why I've asked both of his parents, his mother and father, to be on the call today so that the court can see them. And if the court wishes to ask them any kind of questions or address any concerns that you have about him coming to court, they are here. He will be in their home under basically a parental house arrest, and then any conditions that you would deem necessary, Your Honor, to ensure or satisfy any concerns that you have regarding public safety. He is a kid. This is his first time in trouble. He's never been arrested before. I believe that this is a ripe situation for a bond while we figure out how to go forward in the case. And so we are asking for a reduction of the bond so that his parents can make it. And then, of course, any condition that the court wants to put on as far as PR conditions. I know that it can't be an entire PR bond, but it's too high right now for the family to make. And so we're asking for relief. He will be at home under his parents' supervision while we determine how to resolve or go forward with the charges.
What amount can the family afford?
So if I'm looking at this, we've collectively then for both of the counts have 140. Is my math correct?
I have 135,000 cash surety.
Judge, it needs to be reduced substantially more for them to be able to make it. I know that this is, I feel like this is a high bond considering my client's age, considering the charge. I'm asking for any relief the court can give us to reduce it so that they may post it. I know it can't be a full PR bond.
I had received via email some correspondence, both from parents, I think both grandparents, and an additional individual, I believe from California. Mr. Vandenberg, Ms. Butterworth had shared those with your colleague, Ms. Elizalde, but I forwarded them to you because I thought I knew Ms. Elizalde was out. So were you able to review those? Do you want me to consider those, Ms. Butterworth? And if so, do you have any objection, Mr. Vandenberg?
I have no objection. I have not personally reviewed those, Your Honor.
Did you receive the email?
I don't recall having received it.
Hmm.
I'm not saying it didn't, but
I forwarded it to you at 12:45 over the lunch break is when I saw them. But in any event, the letters, I think there was one duplicate, but there's 4 letters in there. I'll throw into the mix in terms of bond consideration. Anything else, Ms. Butterworth?
No, thank you, Your Honor.
All right, Mr. Vandenberg.
State would object to lowering bond, Your Honor. Even any bond, I think, might be too much on this matter. The facts of this matter are, according to the police, we have 6 separate witnesses, independent people, not known to one another, who were at the restaurant where the incident took place. This happened on El Comeda, and there was an altercation inside the restaurant between the defendant and another man. Apparently, the defendant had a pistol. He threatened the man with it. There were other people who were threatening the restaurant by the mere brandishing of the weapon. There was again, the altercation became more serious, and the offender shot the
Go ahead, Mr. Vandenberg.
The offender shot the victim in the chest. He was sent to the hospital, Your Honor. This is a brazen, vicious attack on a man for no reason that we can see whatsoever. We think he's a danger to the community, and we ask that actually bond be revoked, or if there is a bond, it not be lowered. The witness, I'll just read one witness statement here for the record here. Witness number 6, Miranda stated she and her friend had been at El Cometa when an unknown male grabbed her friend's phone and went into the bathroom with it. Witness 6, Miranda, stated that the male called someone and shortly after the offender arrived, causing problems. Witness 6, Miranda, stated that she doesn't know if her friend knew the offender because I don't know anyone like that. Witness 6, Miranda, stated that a fight broke out and victim 1 was shot. Witness 6, Miranda, stated that her friend left soon after and was not sure if she left with the male who took her phone and the offender. Witness 6, Miranda, gave information on her friend, known only as Anna, with a phone number and an address. Officer Nahara attempted to call Anna to get more of the story, however, was met with negative contact. This is a serious altercation in a public place, and there is no reason for it to have occurred. So the state would respectfully request that bond not be lowered, Your Honor.
May I respond, Your Honor?
Yes.
With all due respect to Mr. Vandenberg, I don't believe that he has done a thorough review of this particular case. The phone incident, the one witness statement that he is choosing to recite, has nothing to do with my client. It's an underlying issue of what was happening and what was going on at El Cometa that my client was 100% not involved in. Really, and obviously, two sides are going to differ in their interpretation of the review of the case. I'm not sure that Mr. Vandenberg has thoroughly reviewed it, but in the defense's summary of what occurred, and Mr. Vandenberg will see in the witness statements, the complaining witness that was actually shot, he and his girlfriend are at El Cometa and have nothing to do with my client. They're there to get something to eat. In their statements, they tell the detectives that there is another individual that's involved that is 100% responsible for provoking this entire incident. And they're not referring to my client. They're referring to the other complaining witness that was added to this particular count, the second one. What is occurring is apparently he has some sort of disagreement. There's some sort of problem between that individual and my client. And the individual that was shot and his girlfriend tell the detectives that it was the other individual that started everything that made it rise to the level it did, went outside purposely to fight my client. My client then does brandish a gun, warning him to back off. And that individual goes back into the restaurant. At that point, the complaining witness that was shot tells detectives that he decides to go out to the parking lot to see if he can diffuse the situation. He knows that my client has a gun, so he comes up from behind to try to take the gun from him. So my client, I'm sorry, Judge, who has no notice, has no idea of who's coming up from behind him, gets assaulted and fires the weapon. There's lots of nuances to the fact pattern, but the summary that was read by the prosecutor doesn't have anything to do with the underlying aggravated assault charges ultimately that my client is being charged with. It is a serious case. I am absolutely not contesting that, but it is far more intricate and a little bit more complex than a vicious shooting as the prosecutor is summarizing this particular case. And really, my client is presumed innocent at this point. He has no criminal history. He's a kid who was in high school and has both parents here ready to vouch for their son, to keep him at home while we continue to figure out how to resolve the case.
One thing I don't recall if I was able to see if there was anything. Was there any 1622 done at the time when he was booked?
I don't believe so, Your Honor.
Yeah, I didn't see one. Is there any mental health concerns that I need to know about, Ms. Butterworth?
No, Judge.
No, may I make a short rebuttal, Your Honor?
You may.
I think Ms. Butterworth has some points there, and I think if we look at other witness statements, they are much more germane to the facts that happened. I'm just going to read from witness number 1, fellow whose name is Nunez, he stated the unknown offender had been arguing with an individual inside El Cometa. Witness 1, Nunez, stated that the argument consisted of the offender wanting to fight outside. Witness 1, Nunez, stated that the offender then left the restaurant. Mr. Perez left the restaurant and returned with something in his waistband. He did not have to return. He could have left and gone away, but he returned with something in his waistband. Witness 1, Nunez, stated that the offender began to taunt and antagonize the male he had gotten into a verbal argument with through a big window on the north side of the restaurant. Witness 1, Nunez, stated that he then observed a gun and started to tell people he had eaten with to get out of the way and laid a table down for cover. Witness 1, Nunez, stated that while watching the offender, a male who was not involved in the altercation, I'm sorry, it's not well written. Witness 1, Nunez, stated that while watching the offender, a male who was not involved in the altercation had attempted to tackle the offender and was unsuccessful and was then shot by the offender. Perhaps that's what Ms. Butterworth was alluding to. There are a lot of events that happened before and after this, and the state does not believe that Mr. Perez's bond should be reduced. He left, according to witness number 1, he left the restaurant and returned with something in his waist and then pulled out a pistol and then used that pistol. We don't think.
Alleged, Mr. Vandenberg, was Mr. Perez defendant, was he alone? Are there I don't see any co-defendants, so there's no.
That's correct, Your Honor.
Was he arrested at the scene?
He wasn't alone, Judge. He was with friends. They're there at the restaurant. There's some sort of underlying teenage drama going on with a cell phone that my client wasn't involved with, but he's there with his teenage friends.
Was Mr. Perez arrested at the scene?
He was not, Your Honor.
Did they retrieve the weapon, or whoever? Did they retrieve the weapon?
I'm not aware of whether they did or not, Your Honor.
Anything else, Ms. Butterworth?
No, Your Honor.
And just so family knows, and so I'm clear on the record, that I do not recognize your client or their family, so no relation that I know of there, just making sure, because there's a lot of Pettis here today, but I did review the correspondence that you provided, and hearing your arguments today, I just cannot find any justification to reduce his bond. It's the allegations, although they are solely allegations at this point. Ms. Butterworth knows just as well as any other attorney how nuanced cases like these can be, and lo and behold, as you all work through them, that might bear out. But for my purposes, for the court's purposes, the request to reduce the bond is denied for the safety of the community. Nature of the allegations, it's just too serious to have allegations of shootings in public places. And I know there are allegations, I understand that, but at this time the court is in agreement. I believe the bond was actually reduced at the jail magistrate, and I'm not inclined to reduce it further. That said, of course, Ms. Butterworth, you're free to file any request for reconsideration as this case is set for trial in January of 2024. Mr. Vandenberg, are you the point of contact in your office on this case?
No, I'm not. Miss Elizada would be.
Okay. We have a judges conference on August 29, 2023. Ms. Butterworth, as you know, with clients that you have in custody, if you want your client present, if you're making that request, please let us know so we can schedule them at the jail docket. To the family, I appreciate your presence here today. But if there's nothing further, then we are adjourned on this matter.
Thank you, Your Honor. Thank you for your consideration.
Yes, ma'am. Thank you. All right, who is next?
Page 22, Judge.
Okay,
Annex, may we have Mendia, Rafael Mendia? This defendant requires the interpreter, Judge. That's why he's here.
¿Qué tal, José? ¿Cómo te vas?
Good afternoon, Mr. Cifuentes.
Pues, ¿cómo le va?
so far so good. Mr. Yanez, are you there?
Hello, Judge. Yes, I am.
Good afternoon. Let's just get the interpreter set up and we can get started. Are we ready?
Yes, ma'am.
No,
No.
no. Interpreter says.
Sí, señor.
Thank you very much. Go ahead, Mr. Murray.
In cause number 2022-0D04316, State of Texas versus Rafael Mendia. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
And Luis
Mr.
Yanez.
Vandenberg, if you would select English, please.
Okay. Can you hear me now?
Yes, sir.
David Vandenberg on behalf of the state is ready.
And Luis Yanez on behalf of Mr. Mendia, we're also ready, Your Honor.
And Mr. Mendia is appearing from the jail annex remotely, as well as utilizing the assistance of the court interpreter, Mr. Jesus Cifuentes. We are scheduled today for a final judges conference. I've got to think we set this because we anticipate that this will be going to trial on July 28th, 2023. Mr. Vandenberg, what's the rec in this case?
10 TDC with a UW finding.
Mr. Yanez, has that been, is that a new rec? Has it been the rec?
No, that's been the rec, Your Honor.
Okay. Are we on track for trial on July 28th?
Your Honor, we are set for trial on July 28th. I'm going to be requesting a continuance for the following reasons, Your Honor. I'm working with an expert. This is a motor vehicle accident that happened on the way from here to Carlsbad, Judge. I've been working with an expert in this case. He's reviewed all the portal evidence in this case, and he just called me Friday requesting a block box from 3 vehicles. Have secure 1 vehicle, but we don't have black box records of the 2 other vehicles because he needs to conduct a forensic reconstruction of this. And there's 2 types of forensic reconstruction that he can do. One he called the desktop reconstruction, where he does it from his office if he's got all the evidence. And if not, he actually has to go to the scene of the alleged crime, which is closer to the New Mexico line. So he took time since the last time to review all the evidence that's been provided to the defense through the portal. But he just told me this past Friday he's missing that. I did call Ms. Elizalde on Friday and sent her an email, but I believe she's out of the office until later this month. I think it was the 19th, whatever response I got from the email. And that's where we're at, Judge.
Okay.
I do need that instruction in a case like this, given the technicality of the events. It's a motor vehicle crash. My client contends the other drivers caused the crash, and that's going to be a fact issue for the jury.
Okay. Mr. Vandenberg, I'm hearing that this is Ms. Elizalde's case. Are you up to speed on this case, or?
I know a few things about it, Your Honor.
I'll say this, Mr. Yanez, I think we've had 1 reset, but I hear what you're saying. So We have our final hearing plea deadline that Tuesday before the 28th. The sooner you file your motion for continuance, the better. I don't necessarily need to have a hearing on it if I'm not hearing any opposition from the state. And I can tell you right off the bat, so both of you all know that because Odyssey is so slow, I'm not able to say this too definitively, but I don't think we can squeeze you in. I would want to set this especially because your client is in custody. And I don't think we can fit you in 2023. I think I would just kind of be stabbing at dates and hoping that other cases fell through rather than give you a date that I can actually set aside for this case. Mr. Yanez, you know, your client is in custody. So I need to be assured that he is in agreement with a continuance, all of those things in light of a January 2024 trial date. And I'm saying January 2024, lo and behold, if I can get on there, I may find that we go into February on a special setting.
Yes, Your Honor. He has been advised of the rec and he has been advised of what's going on.
Mhm.
We'll continue to work on a possible resolution to this case short of trial.
Mhm.
I haven't received any complaints or any disagreements with this trial being continued.
Since we're here just on a final, judges, I appreciate you being thorough and keeping the court apprised so that, you know, I think I had this at least, I know it's not specially set on the end of July, but I think I had it in my mind as this was the case that was going to go that week. So I don't want to change anything right now. File your motion and I will consider it at the final hearing plea deadline. I would encourage the state and you, Mr. Yanez, if there is some change in any or potential for change in any kind of recommendation on this case, that you know, you do it now. I know if we can do that ahead of the July final hearing plea deadline. If not, I understand that there's still work to be done, so that may happen further down the road. But I'll consider your motion for continuance at the final hearing plea deadline, okay?
Yes, Your Honor. Thank you. And I'll contact Mr. Vandenberg, see if he's, we can discuss this case. I know it's Ms. Elizalde, but maybe
Okay.
he's got authority.
Yeah, we can do
Sounds
that.
good. Mr. Mendia, we have we have a trial date set for the end of July, but as I'm sure you've understood what your attorney is saying, he's got some work that is critical in his mind for your defense. And so he may be making a request to move that trial date. I will consider that request at our next setting, which is the end of July before our trial setting, current trial setting. Okay. All righty, Mr. Yanez, thank you very much. Thank you very much for your time.
Thank you, Your Honor. I do have one more. Do you want me to wait around, Judge?
We can take care of that one. I just want to know if we still need the interpreter. Thank you, Mr. Mendia.
My next client speaks English, Your Honor.
Beautiful. Does anybody else need the interpreter, Marufo?
Judge, the annex asked for a interpreter for Miller Victor also.
Victor Miller. Okay, let's take care of that one and then we'll go back to Mr. Yanez's case.
Yes. Annex, may we have Miller?
Yes, it's coming up.
Yes, sir. M-I-L-L-E-R.
Go ahead.
In cause number 2022-030-3762, State of Texas versus Victor Manuel Miller. Announcement of council, please.
David Vandenberg on behalf of the state.
Rick Hoffman on behalf of Mr. Miller.
Carlos Ruiz, adult probation.
Okay, I'm sorry, Mr. Ruiz, I'm reviewing, and Mr. Miller is appearing from the jail annex, utilizing the assistance of the court interpreter, Mr. Jesus Cifuentes. We are scheduled for a probation status hearing. I have a notation here regarding the results of an evaluation. I feel like we have discussed this before where BHRTC was not, or probation was saying BHRTC is not available because he had not had positive tests.
That's correct, Your Honor.
And then it says here, CSO then advised that he will have an Aliviane assessment tomorrow at 1:30. So I'm assuming that's what we were coming back on, Mr. Ruiz?
Yes, Your Honor. That was on June 21st.
He was a no-show?
He was a no-show. So apparently what I got from Aliviane is that, well, Mr. Miller never called. So I'm not sure if the officers didn't make the phone call or I don't know what happened exactly, but I was able to secure a new appointment for July 19th. So that's where we are right now.
How long has he been in custody? I'm not sure. So he was supposed to be calling from jail? Is that what it is?
Yes, Your Honor.
Oh, okay. All right, Mr. Huffman?
Did they want to make him to make a collect call or how does that work?
Oh, yes, they have to set it up, which the officers did confirm that they were gonna set it up. So I already passed the whole information to them. So they are aware of the new appointment.
So they're
Okay,
gonna
so
set it up?
probation is setting up a phone call with Aliviane and Mr. Miller. Is that what it is?
Yes. So Mr. Miller has to call from the jail to Aliviane.
So, yeah, I'm kind of wondering how he ends up being a no-show. He's in
No,
custody. Yeah, I mean, that's a little.
That's what I got from the director, Your Honor.
Okay, so it was set up the previous time and he didn't make the call. Is that right?
That's what I'm getting, Your Honor.
Mr. Huffman, did you have any information on that?
Yeah, I highly doubt that was intentional, Judge.
Yeah, I'm good to go to that, wait until that 19th appointment, but I can hardly think that it's a no-show situation. Maybe there's just a miscommunication. I'm happy to come back on a probation status hearing to see if we can get this taken care of on not July 20th, on July 25th at 3 p.m. Mr. Huffman, does that sound reasonable?
Yes, Judge.
Mr. Reese, I'm not sure exactly how this happens. I'm a little confused by it, but I'm resting on your assurance that it is being set up and coordinated with probation, Aliviane, and the jail. Is that right?
Yes, Your Honor.
All right. All righty, then that's what we'll do. Mr. Miller, we're going to come back after you have your assessment through Aliviane.
And Judge, just so we're clear, just so Mr. Miller and I are clear, they're gonna pull him out to make the call, or does he need to like make a special request with the DOs to do it?
Mr. Ruiz, do you know that?
Sorry, I couldn't hear Mr. Hoffman. Can you repeat that?
So, yeah, so are they gonna pull him out and give him a phone and allow him to make a call? Is that how it works?
That's my understanding.
Okay, so it wasn't him?
It wasn't him.
DOs last time that did not do, okay.
Okay. All right. Mr. Huffman, you might want to make an inquiry there, before the 19th to make sure that we're not spinning our wheels here. If not, we can do something else. Maybe we just bring them in person and have somebody do the assessment here.
Okay.
Okay. All right. All right. We'll come back on the 25th at 3 p.m. Thank you very much.
Thank you, Your Honor.
Thank you, Mr. Miller. Thank you, Mr. Cifuentes. I don't know. Are we done?
We're done, Judge.
Thank you, Mr. Cifuentes.
Yes, ma'am.
Who was Mr. Yanez's other client, Mr. Prieto?
Yes, Judge, on
Yes,
page 24, Judge. Annex, may we have Prieto, Anthony?
Yes, sir.
Go ahead.
In cause number 2017-0D00772, State of Texas versus Anthony Prieto. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
And Luis Yanez on behalf of Mr. Prieto, we're also ready, Judge.
Let me go back. We're set for a probation status hearing.
Yes, Your Honor, we had been set on this case I did a motion recall, the KPS, this is a case that had been pending for a while, 2017 case. You said that you wouldn't consider that, but we'll consider 6 months if he turned himself in. He turned himself in per the court's instructions, and if the state is okay with this, would be willing to sign off on those 6 months, Judge.
Okay. Do you have, let me see, Mr. Vandenberg? Can you get this plea of true papers going?
Yes, we can do that.
We'll set this for a plea of true, let's see. I'm afraid we're probably looking, Mr. Yanez, at August 1st.
That's fine, Judge. You have the 6 months, so we have time.
Okay. Yeah, August 1st, 3 p.m. Plea of true. Please send those plea paperwork. Please send the plea paperwork, Mr. Vandenberg. Mr. Yanez, thank you for your time.
Thank you, Your Honor.
You may be excused. Thank you, Mr. Prieto. Who's next?
On page 20, Judge. Second on page 20. Annex, may we have Gallegos, Germán?
Gallegos.
In cause number 22 2366 State of Texas.
Wait a minute, there's an echo.
Is going on. Please restart.
In cause number 2022 0D0 2366 State of Texas versus Germán Giovanni Gallegos. Announcement of council, please.
David, on behalf of the state, state is ready.
Good afternoon, Your Honor. Jeff Rago for Mr. Gallegos. I apologize. I'm in a bad area. I was going to have Samantha do this for me since I was out of town, but she actually was the prosecutor on this. So I'm going to be on it. Yeah, so I was going to have her cover for me, but that's not going to happen. So I got really bad service right now. I'm trying to keep service. So
We are set for a probation status hearing. Let me review the case summary. So it looks like he was modified, he was out of town, came back, looks like in January, but didn't report here in El Paso, and we got the bench warrant in March.
there may also be a new case, Your Honor.
Mr. Vandenberg, is there a new case?
Let's see. I don't have a record here. We have two P files filed on May 30th. So this year, one is burglary of a building, P file 2023, P file 05712, and the second one is evading arrest or detention. That's a P file of 05711.
Oh, let me see. Where are those cases? Are they with your office?
They're with the office.
Have you filed a motion on Mr. Gallegos?
No, Your Honor, have not.
Have we sent that, Ms. Pineda, a violation? Let me go back. Okay, I see it.
Your Honor, if I may, I believe there is a motion filed. It was filed prior to the new arrest. That's what I'm trying to log into Odyssey to check.
I may need an amended motion. I see a motion.
Correct.
Motion to adjudicate was filed April 5th.
Yes, but I don't believe it's alleging
The new offenses.
from, yes, from me.
Yeah, so it looks like you may need to update your motion to adjudicate. There is one on file, so we can have any new allegations. Maybe they need an updated VN. Mr. Rago, are you appointed on the new cases?
That I'm not sure about, Judge. I did see the, just found out about that this morning on the new case, so I didn't really get to check it that much. I will look into it. And if so, we'll file a examining trial, whatever we need to speed it up.
And Judge, I do see here order appointing attorney for Mr. Rago on the on the P files, and that's for May 31st.
Okay, so you were appointed a little over a month ago. Do we have a future setting on this? We'll come back in 30 days on a probation status hearing again between you, Mr. Rago, and you, Mr. Vandenberg. Whether we're talking about examining trial or just tracking down the case to see if you're going to get those presented to the grand jury. We'll come back in 30 days and we need to make a notation that he has new cases, new 2023 cases. I think we're just looking at revocation in terms of his probation case, but obviously, Mr. Rocco, you'll need to be looking at those new cases as well. So we'll come back in 30 days. Thank you very much.
Thank you, Honor. May we be excused?
You may. Who's next?
Then on page 20, Judge. And next, may we have Marcus Hernandez?
But this is the one where Mr. Hernandez has two attorneys. Is that right?
Yes, Your Honor. We are on the possession case, and I can't remember the name off the top of my head, but there is another attorney on the Berg tab.
Yeah, it's Enrique Lopez. All right, go ahead.
Thank you, Your Honor. So in this case, Judge.
No, I'm sorry, Mr. Marufo. I meant Mr. Marufo. Sorry, Mr. Nunez.
In cause number 2023 0D01446, State of Texas versus Marcus Ryan Hernandez. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
And David Nunez on behalf of Mr. Hernandez. Ready, Your Honor?
We're scheduled today for a hearing on the defense motion to recall the KPS or warrant. Mr. Nunez, you may proceed.
Thank you, Judge. So, Your Honor, the bonding company in this case filed an affidavit of incarceration with the court, and the court subsequently issued a KPS on May 2nd of 2023, all of which was in compliance with Article 17.16 of the Code of Criminal Procedure. When the KPS was issued, Mr. Hernandez had already been in custody and had been so since October 22nd of 2022. So as such, Judge, we're just simply asking the court if to exercise their discretion in recalling the KPS due to the fact that Mr. Hernandez was already in custody when the KPS was issued. And under Article 17.16 subsection D2, it states that a KPS is not required if the issuance of a KPS would otherwise be unnecessary for the purpose of taking the accused into custody. Again, when the KPS was issued, Mr. Hernandez was already in custody, Judge. So
that was back in October. So back in October, I'm just trying to go through the jailing here. It looks like we had, let me make sure. Okay, so we had the KPS on this case on the cause number ending 1446. He was booked on that. And then he was also booked on the new ag robbery and burglary of habitation. Is that right?
From my understanding, yes, Judge.
Okay. And just so I'm clear, because I'm just looking at the jailing, the ag robbery and burglary of habitation, those are the ones that Mr. Lopez I'm assuming he's appointed on.
Yes, I think he's retained on those, Judge. I'm the one that's appointed on this case.
Yeah, okay. All right. So, Mr. Nunez, are you saying that because he was booked on the other two, on the ag robbery and the burglary of habitation, that the KPS is unnecessary? What are you saying?
Kind of, Judge, but I guess technically what I'm saying is that because he was already in custody, there was no need for the KPS to be issued based off of the affidavit of incarceration filed by the bonding company. And that serves as the basis for the KPS that we're here on right now. And it's in the court file, Judge.
I went back, I thought I reviewed this a little bit yesterday. Let me go back. I'm in a different module here. Let me go into the events. So let's see, we go into the events. Okay, order appointing, and then we get the motion to exonerate surety in December of 2022. Am I looking at the re-up? This is it. Motion to withdraw. What's this?
546 20 Yes, he's in charge of scheduling these hearings, and he'll guide you through the process. That way we can get us and we can.
So they filed a motion to withdraw their motion to exonerate surety.
It will be good for them.
What's the date on this? Back in December. Okay. And there's the order, indictment, motion, and leave motion. And then we get our affidavit of incarceration. Yeah, I see. Okay, Mr. Vandenberg.
Well, we think that the KPS should be retained just because for the record of the actions of Mr. Hernandez here. I've been looking through the documents as well. They're pretty skimpy. There really is not a lot to go on here. I do think he is in custody. That's not an issue right there. So the purpose of the KPS is actually mooted, I think, in most referrals. But the fact that it was issued is on the record. And I think that suffices as to the need of what happened here.
So are you opposed to their request to recall that KPS?
No, Your Honor, I'm not opposed.
Okay, so the request will be granted, Mr. Nunez. Mr. Valenzuela may have provided a proposed order. If you would just out of courtesy, send it to Ms. Hernandez so I can sign off on that. Or maybe we can get it from Ms. Melendez. I'm not sure. In any event, if you send something, either that or our order will come through. Okay?
You got it, Judge.
All righty. Anything else?
No, Your Honor, may I be excused?
You may. Thank you very much.
Thank you. Bye, everybody.
Bye.
Bye-bye. Let me just make sure that these cases are tracking each other. Yes. Okay, on his cases, Marufo, on July 18th, I think we need to have, they are tracking each other on that setting. They need to come before the judge because I'm not sure what we're doing with two attorneys on two different cases. So, all right. All right, who's next?
Staying on top of page 20, Judge. And next, we have Aguilar, Ivan.
Mr. Huffman, is that you?
Yes, Your Honor.
All right. What's his bond? Because I have a pretty big PSR, pretty thick PSR on him.
Judge, I'm showing a 10,000 cash already.
All right, go ahead, Mr. Maru.
Because number 2023-0D02997, State of Texas versus Ivan Aguilar. Announcement of council, please.
David Vandenberg on behalf of the state. The state is ready.
Rick Huffman on behalf of Mr. Aguilar, we are ready.
All right, we're scheduled for a bond hearing. The clerk is telling me he's at 10,000 cash surety. Mr. Huffman, you may proceed.
Thank you, Your Honor. Judge, my client has not been able to pay the $10,000 cash or surety bond. He's 30 years old. He's a U.S. citizen. we've got, he's got a place to live. He can stay with his mom. But he would prefer to stay at the rescue mission, which we've got him a referral to. So we've confirmed that there's space in the rescue mission. The reason being, Judge, is because his mom is taking care of the nieces. And there's just not a lot of room in that house. But mom is okay. Mom is willing to help out. But to save her the burden, we're asking the court to basically order, if released, order Mr. Aguilar to live at the rescue mission. He wants to do Takumi, Judge, and he wants to do OSAR to address his mental health issues and any substance abuse issues. He's got an 8-year-old son, and he wants to get his life together and be there for that young boy. He doesn't think he's ever been convicted of a felony. And Judge, it's my understanding that he has been on probation before and he has completed it. He promises to comply with any conditions the court requires. Judge, he had, as far as the facts of the case, there was no accident, there was no damage to the vehicle. The allegation is that he basically took the car for a joyride for a day and left the car down the street.
So, but I'm just looking here at the PSR and the previous booking. He was booked in 2022 from June 6th to October 3rd in the 34th District Court. They put him out to time served on a theft with 2 priors. And he gets out. What's the alleged date of offense here?
It is May 4th.
So about 6 months later, we got a new case. Possession of drug paraphernalia, failure to ID.
And possibly, Judge, he was dealing with some anxiety, some depression issues. He's taking medications in the jail, and he's got access to some mental health services. I assume that may have contributed to this poor decision. So we're hoping he can get out and show not only the court but the DA's office that on the right medication and with the right treatment, he'll be okay.
All right. Anything else, Mr. Huffman?
Judge, he did cooperate with the police officers too. And I would like to ask the court to take that into consideration. I mean, obviously against my advice, but he did cooperate.
All right, and I'm assuming no resources, no financial resources. Is that right?
No.
Okay, Mr. Vandenberg.
State would object to lowering a bond in this matter. Your Honor, you were talking about his priors, and that's the state's concern. We have a series of our convictions already. Theft of property, one case 2022, that's just last year. That's 29 case that ends in 2099, case that ends in 1986, also from 2022. He also has an ag assault with a deadly weapon from 2018, and from 2017, a theft of property again. This is a series of events that the defendant has in his control, but he just keeps on deciding that this is what he's going to do. He's going to steal other people's property, and there has to be a stop to that. And if he can't stop himself, then there's going to have to be a stop by the court, Your Honor, which is unfortunate. But we have a series of events, series of thefts. We see no end to this. I sincerely believe that if he's released, if he makes bond on this, then he will reoffend, steal someone else's car to take a nice joyride, or to do other things with that. So the state objects to this. If you look at the facts of this case, again, it did happen May 4th, 2023, 3 a.m., approximately 1942 hours. And what happens is it seems to be a matter-of-fact way of living for the defendant. So again, we'd ask that bond not be reduced, Your Honor.
Mr. Huffman, do you have anything else?
Judge, if the court's wondering, he's a landscaper and he does have work if released. But that's all.
Fortunately, looking at the OSAR history, I mean, not only do we have so many, there's two types of offenses happening here, assaults and thefts, failures to ID in there. But there's nothing that the court really can hang a decision to lower the bond on, because every probation was revoked. Everything else has been a time served type rec, even on reductions in all of these cases. I'm seeing he was in the 41st, he was in the 168th, he was in the 34th, now he's in the 210th. So I'm not going to reduce his bond because of prior non-compliance, safety of the community. I think he's a flight risk, his inability to conform with the conditions of bond. But I am hearing what you're saying, Mr. Huffman, if he has not, for example, been offered the opportunity for treatment, things of that nature. I know we're very early on, there's a lot to look at, but I'm not reducing the bond, but if your client is asking for help, the court is very open to that. So you all need to get talking. But I know we're early on, so with respect to the bond, that reduction is denied. Thank you very much. All right, who's next?
Towards the bottom of page 25, Judge. Annex, may we have Trillo, Alejandro Trillo?
Go ahead.
In cause number 2023-0D02877, State of Texas versus Alejandro Mario Trillo. Announcement of counsel, please.
David Vandenberg on behalf of the state, and the state is ready.
Rick Huffman on behalf of Mr. Trillo, we are ready.
We're set for a bond hearing today. Mr. Huffman, do you know what the bond is?
1 second, Your Honor.
Judge, I'm showing it's 75. Cash surety.
75,000, is that what it was?
Yes, Judge, sorry.
Thank you. All righty, yeah, it looks like it's 75. Total is 80,000, but go ahead, Mr. Huffman.
Thank you, Judge. Your Honor, my client doesn't have the financial resources to pay the bond. We understand that the court has to put a bond, but we would ask the court to put a reasonable bond. Through his family and friends, he might be able to afford a bond in the range of $1,000 to $1,500. Mr. Trillo is currently not working. He suffered a traumatic brain injury from the complaining witness, who's his ex-girlfriend, pushing him out of a vehicle and him suffering a pretty bad injury. The complaining witness is also on probation for assaulting his mother, and I think my client's brother, who's handicapped. There is a video in this case, Judge, and the video does show my client, Mr. Trillo, throw a water bottle at the complaining witness, but there's no gun involved. There's just nothing there as far as a gun. There is a water bottle that was thrown at her, but that was it. We do have a witness as well that was there at the time that claims there was no gun involved at all. We think that this complaining witness is making this up. So because in retaliation for the cases that she has pending and the cases that she has that she's on probation for. Your Honor,
How long has he lived in El Paso? Looking at the PSR, he has some history in San Antonio.
I'm gonna find my notes. He resides with his girlfriend at he does have an address, but I do not have may I ask my client?
You may.
Mr. Trio, are you a US citizen?
Yes, sir.
How long have you lived in the El Paso area?
I believe all my life. Me and my mom and my family went to San Antonio to live at least 4 years over there.
Okay, and when did you get back?
It was 2020.
Okay, now where are you living now? If released, where are you gonna go live?
Oh, it's with my girlfriend. It's not Diana. It's my new girlfriend. We've been living there for a year. It's a 10717 Regina Drive, Paso, Texas 79927, apartment 4.
And you all are renting at that place?
Yes, sir.
Does your girlfriend have any criminal history that you know of?
No, sir. She's actually my care provider.
Care provider for what are you suffering from?
Mental loss and injury causing brain damage. And then they're gonna operate me to get a cyst out of my brain that's being a little bit of taking a space in my head.
Are you having seizures or anything of that?
Yes, sir. I do have seizures.
Are you getting treated in the jail?
Yes, sir. I do get treated. I've
You feeling
been
okay
having
there?
seizures as well here.
You are having seizures?
Yes, sir.
Are you getting seizure medication in there?
Yes, sir.
Okay. Are you feeling okay in there?
Yes, sir. I went to the mental health clinic, I think, and they diagnosed me, I think it was on Monday, with depression and anxiety.
Okay. I have nothing further, Judge.
All right, Mr. Vandenberg.
The state would oppose a reduction in bond. In communication with the CW, she's very concerned. She says that the defendant has made threats to herself and to her children. These are verbal threats. She says they've been recorded. I haven't seen anything about that.
Was there ever a protective order?
I don't believe so, not on this one.
So when he was first booked, they didn't, I mean, he was booked on the ag assault, deadly weapon and assault, family violence. He's
Right.
got prior family violence history. They didn't get a protective order?
I don't believe so. I've not seen that.
And Judge, I'm not seeing one filed either.
Thank you, Ms. Melendez.
And Judge, he would be 100% okay with a court order to stay away, have no contact with Felicity.
Is the complainant in this case currently a defendant? Just
No,
that,
she's on probation. I think she's still on probation, but she may have just finished. But it was for an assault, and the complaining witness in that case was my client's mom and brother. And she had a few other cases that were dismissed, one being a felony.
who are the victims or who are the complainants in the previous? So I have a family violence from 2021, November 2021. Who was our complainant there? Do we know? Because that was a capias there too. So that's we might have some issues with being able to comply with bond conditions.
I don't see a case. Is it the misdemeanor in 2021?
Mm-hmm. This is in CC7, but I cannot see. Let's see, back.
The victim in this one, the one 2021 ending in 1025, is Diana Pichardo.
So that's different from this one. This one's Diana Melendez, is that right?
That's correct. That's correct. It's different CWs.
All right. So the state is opposed to any reduction in bond, is that right?
That's correct. Because of the threats that have been made and the history.
So I am going to reduce the bond, but I don't know that he's going to have the resources to even meet that, Mr. Huffman. It's going to be a $20,000 split, 10,000 cashier, 10,000 PR. He is to report, well, obviously he can't reside. I don't know if it sounds like he's already residing somewhere else with someone else. So he cannot have any contact with the complainant, not direct contact, not through a third party, nothing of that nature. And he may not be within 200 yards of the residence of that complainant or her place of business. They don't have children or anything like that, Mr. Huffman, they do?
That's the big problem, Judge. But, I think Mr. Trios is just gonna have to stay away for a while, unfortunately.
What is the arrangement for, is there some kind of legal arrangement in terms of?
No,
All right.
Judge, and that's why that's how this incident started.
All right. Well, if you need further modification of the conditions because something happens if he does bond out, we can look at that. He's going to report once a month. He's going to have a curfew from 10 p.m. to 6 a.m. unless he is working or going to school, to use no illegal drug or alcohol, subject to testing. The mental health angle of it, he will be required to comply with any mental health treatment. I'm hearing he's receiving some treatment in the jail. I'm going to assume, Mr. Trio, that you had some kind of mental health treatment when you were not in custody. So that will be a condition of your bond. Mr. Huffman, he's raising his hand.
Yeah, go ahead, Mr. Trio.
My doctor, I have for the drug testings, I do have medical records that I have that I use THC.
No, right.
So that's
That's
legal.
something that I have on my
You can't. It's in Texas. You can't. Well, you have it's in Texas. You have
it's in Greenhouse, downtown in El Paso, and then the doctor signed it. I was in drug court, and they dismissed it as well.
Because they do have some medical exceptions for that, Judge.
It's registered on my ID, I believe.
So that kind of falls into two things, right? So if it's part of your mental health treatment, that's one order, right? That's one order of his conditions. You might have to look into that, Mr. Huffman. I'm not sure about the details there. But otherwise, it's prohibited under your bond conditions.
Okay.
It is. Okay.
And you may not change your place of residence or leave El Paso County without court permission.
Yes, Your Honor.
Any other conditions? You're to possess no weapons, to include firearms, any firearms or ammunition. That's what you may not possess. Anything else? Any other conditions? I think we only have the one complainant. Is that right? Or we have more than one?
Oh, there's another individual involved. I guess the new boyfriend of the complaining witness.
So yeah, no contact, obviously, with either one of the complainants.
Yes,
All right. Okay. We'll get the bond order. Thank you very much. And we have settings, right? Okay.
Yes,
next. Thank you, Mr. Trio. Who's next?
Thank
Bottom
you.
of page 20, Judge. Annex, may we have Roberto Hernandez?
Good afternoon, Judge.
Good
Can you hear me
afternoon.
okay?
Yes, thank you, Mr. Morales.
Yeah, sorry I had to keep popping in and out, Judge. We're still in the middle of this jury selection in this capital murder, so I'm a little tied up.
Mr. Hernandez, is that you? Can barely see you. There you go. Okay, go ahead. Is that your client, Mr. Morales?
It is, Your Honor.
Thank you. Let's get started.
In cause number 2021 0D02898 and 2022 0D03199, State of Texas versus Roberto Hernandez. Announcement of council, please.
David Vandenberg on behalf of the state is ready.
And Your Honor, Leonard Morales on behalf of Mr. Hernandez.
Mr. Hernandez is appearing remotely from the jail annex. We're scheduled for bond hearings in these cases. You may proceed, Mr. Morales.
Yes, thank you, Your Honor. Judge, the last time we were here on a bond hearing was back in November of last year. Since that time, I know we've been back and forth with negotiations and other matters trying to resolve this case to one extent or the other. However, we've not been able to reach an accord that my client is necessarily satisfied with. Nevertheless, he's asked me to come back and re-urge a bond reduction in his case, Your Honor, for the same reasons that the bond is rather high. I know the bond on the 2898 case was $100,000 set back on November 8th of 2022. The other cases all remained the same. So those bonds, obviously, Mr. Hernandez has not been able to make. He's asking for some relief, some reduction of those for the time being. I know that we're scheduled for jury trial later this month, or for trial later this month. However, I know that for my purposes, I'm going to be unable to try the case later this month, Judge, because of my prior commitment in Criminal District Court 1 in this capital murder case. And additionally, I don't know necessarily if Mr. Hernandez even wants me to be his attorney anymore. I think we've reached something of an impasse in various areas. And I don't know if, and actually, I don't know is probably the wrong way to put it, but if we could just end up with the bond hearing first, and then I'll take up the next issue later, Judge. But nevertheless, for those purposes, Judge, we'd ask for some relief on the bond. As you know, Mr. Hernandez has lived here in El Paso. He's not really a flight risk. I know if there's any concerns, it may be some relapse into drinking or some other violent incident that the court might be concerned with. But I know that my client was previously being seen and helped by the Emergent Healthcare Network. He had been seeing therapists there for some time and had been making some progress. Additionally, Your Honor, he would not be residing with the complainant, Ms. Ariola, but would likely be residing with his parents who live here also in El Paso. We have addresses and phone numbers for them. However, I'd rather not put those addresses on the YouTube, Judge, but I can provide those to the court after the hearing. Again, that would be separate and apart from Ms. Ariola and his and their children that they have in common for the time being, and for obvious reasons, Judge. So we'd ask for some reduction in the bond, Judge, for the time being, and see if we could get some relief for Mr. Hernandez in that regard.
All right, Mr. Vandenberg.
Yeah, thank you, Your Honor. The state would object to this, and it's for the basic reason that the defendant continues to reoffend against the same CW. We have these two cases here, and we also have the misdemeanor case 2020 0C as in Charlie 01289. And there's a long-standing history of many years in which the defendant goes back and assaults his family members. Again, there's no excuse for this. Apparently it's related to a drinking problem or a drug problem, but the state has concerns for the safety of the family members that he's assaulted numerous times. and his inability to control himself in that regard, Your Honor. So we would ask the bond.
Okay, what are you doing on the new case? What is the offer on the new case?
The new case, that would be the 2022? Is that correct?
Yes, it is set for trial in, I think it's next week. So not this trial week, but the following week.
Judge, if I may, I know Mr. Vandenberg is somewhat new to the case. The last offer I received from the state, not from Mr. Vandenberg, but the last offer I received was 5 TDC. There was also a counteroffer presented by us that was looking for something along the lines of safe P and a continuation on probation. However, I know my client's not really inclined to do that either, or take the time. So we're at something of an impasse. But I know that we were in the middle of those two recommendations.
Your Honor, the state would look at some kind of probation as long as there is safe P involved, BIP, TAP, no contact with the CW. But in terms of reducing bond, again, it's questionable whether the defendant can control himself in these areas.
So when we're looking at the bond, the reason he has the high bond, and I know we've probably addressed this at the previous bond hearing, so your client is aware, is because while he was on bond on, while he was on probation for an assault family violence, and we picked up a new one, and we are right at trial. And I understand kind of some of the intricacies of your availability, Mr. Morales, but if what I'm hearing from the state is, so I'm not inclined to reduce it. I am not inclined to reduce it in terms of a bond reduction, that's denied. But your client, Mr. Vandenberg, this defendant has been in custody for at least a time of the docket, 324 days. And so I'm not sure if your client is just not inclined to plead, Mr. Morales. But if I'm hearing the state now possibly entertaining the idea of probation, then we really need to address that because he's been in custody for a year. So that's what I'm asking you, Mr. Vandenberg. Are you saying that you're at probation? Or you're likely to be? Because if you are, then I need to know that, because then we can start to tailor conditions and actually work on that.
Yes, Your Honor, the state is at probation.
So what's the rec?
5 straight probation, Your Honor, with safe P, TAP, BIP, UABAs, $3,000 fine, 300 hours of community service, no contact with complaining witnesses.
Miss Carla, are you there? I don't know if I had, and maybe let me look back. Let me see his probation summary. I bet there is one here. Yep, there it is.
Very often in these recs, sometimes we say no offensive contact with complaining witness, but because of the defendant's record, state thinks there should be no contact because of his inability to keep himself under control.
So I'm looking here, Mr. Morales, it appears like on the June 27th, we had a hearing, but you may have had a scheduling conflict. The state did advise that their rec was 3 TDC and dismissal of the new case. Am I looking at the right summary, Carla? 3 TDC and dismissal of the new case, or a plea on the new case, continue on probation with safe P placement and domestic violence caseload modification. Is your client open to safe P, Mr. Morales?
I mean, we've had those discussions, Judge. At least as far as the some of the recs that you mentioned, Judge, the 3 DDC was never communicated to me. If that offer was put out there at some point in time, I hadn't heard that, and it was never communicated to me. But neither here nor there. The safe P we had discussed, yes, but I know that my client is somewhat inclined to participate in that. But then again, his main goal is to try and stay on probation from what is my understanding. Is that still how you wanted to do this, Roberto?
Sir, you came to me with the offer back in April. I continuously asked whether it would be back on deferred, and you let me know a month later that it was one of the recs that I would do safe P and get back on deferred. And when I questioned about how much time, sir, you told me to sit tight. And by the time the next
Well,
offer.
Roberto, without going into too much detail, are you willing to do safe P with the probation?
Well, I was understanding that it was deferred, sir, what you initially had told me.
Okay, well, I don't think Mr. Vandenberg is offering defer. That's sort of where we stand, Judge.
That's correct.
So the last notation here was that the probation officer visited your client and he stated he is doing much better. He would like to get all the help that he can. That I guess, you know, you're no longer with your wife and you're going to take this as an opportunity to work on yourself and seek treatment. I mean, what are we talking about needing to address through Safe P? That's what I want to know.
My alcohol abuse, ma'am.
Are you open to that type of treatment? I'm understanding from your attorney that you all have discussed it. Is that something that you're willing to accept?
Well, I was when it was deferred, ma'am. 2 months after the initial offer of deferred probation, it all of a sudden turned to straight. And I never had a clear detail to make my decision on when it was deferred. I would have jumped on it back in April had I known the full details, which I was never given.
Well, I don't know that
Because
those
we
were
don't, because,
those
well,
were there at
without
that
going
time.
into too much detail, yeah, without going into too much detail about
So-
it, Judge. Yeah,
So he's on
Go ahead,
deferred on
Judge,
my
I'm sorry.
probation. He's on deferred on my probation case,
yes,
and they're
Your Honor.
offering straight on this one.
Yes, Your Honor.
Let me just throw out a couple of things. So if what we're talking about is, does he have, well, obviously he does, if this is a, let's see. Yeah, with the prior. I'll tell you this, Mr. Hernandez, the court is not at deferred, okay? The court is not at deferred. And that's not what the state is offering. The state is offering straight.
Okay.
But I very much appreciate your recognition of, you know, some type of treatment. I'm seeing this notation in here of 3 TDC, Mr. Morales. I mean, I don't know if that's, you know, I don't know how much your client wants treatment or not. If we're really talking about straight, maybe treatment doesn't mean so much anymore and he just wants to take the time rec and be done with everything.
I understand, Judge.
But I am absolutely willing to offer him treatment if he feels like he wants to take advantage of that. I know it's work, Mr. Hernandez. I know that's work. And maybe because you've been in custody so long, you feel like, you know, you've been away from all of those things that got you on the wrong path or vulnerable to those influences. But I do feel like we're at a point where this, yeah, like we need to figure this one out. And if the state is now saying probation,
I think that Mr. Morales has a good point. I think it's worthwhile to look to see if there's treatment that can help Mr. Hernandez, whether it's Safe B, anger management, TAP, any of these things, because he's going to go one way or the other. It's best if
so
you
the
go.
last case before our probation case was the misdemeanor case in CC2, and he was on probation for an assault, family violence, and he was revoked there. That's where we get our underlying prior for my probation case. And then of course we pick up. The recommendation from probation is to order him to BIP so he can be placed on the domestic violence caseload as he has been screened and qualifies.
Yeah, it's a lot of work, Judge. And that's what I've been trying to impress upon Mr. Hernandez is that the probation that he's asking for is not going to be an easy one.
Right. So I'll throw this out there, and I know I don't trying to muck things up here. Is that if he is inclined to do that level of treatment and to really take it upon himself to fix whatever he's got wrong with him that's making him mess up, I would entertain deferred and extend him. If we can extend him, I think, yeah, we should be able to. on his original probation, if he's willing to do that work.
Yes, Your Honor, I definitely am.
I don't want to hear Mr. Hernandez. There's a lot going on right now, and I'm not trying to be rude to you. But if you're making that representation that you really feel you need some help, even after all the time you've been in custody, then that means something to me, Mr. Morales, and I'm willing to extend treatment. But I'm sure there's this idea. I mean, Mr. Vandenberg, I'm seeing in the probation summary here that the rec for a revel was 3 TDC. You know, the easy way out is to say revoke, plea, 3 TDC, wrap everything up, be done with it, and you have 2 convictions.
That's right. That's right. That's the easy way.
Is that the rec on the table?
No, Your Honor, if Mr. Hernandez believes he can make a difference in his own life and do the things he needs to do to change himself around, the state is very willing to give him an opportunity to do that. But you don't get 2 opportunities. You don't get 3 opportunities. You get 1 opportunity.
I just want to be clear. Is there an alternate TDC rec to the safety? I
don't know. I'd have to look at the case more deeply at this point. There could be.
So I don't know who the ADA was on June 27th that made that offer of 3 TDC. So I'll let you all review.
Yeah,
that.
I mean, I had been sitting on a 5 TDC rec for a while, Judge, and as I said, I wasn't notified of a 3 TDC rec. I mean, I'll welcome it if that's a recommendation. I take that to my client as one option as opposed to the probation option that Mr. Vandenberg's talking about, and let him decide. As the court's well aware, Judge, I don't twist my client's arms to do anything. So it depends on what they want to do.
All I see on this case summary is ADA's rec is 3 TDC and dismissal of new case or plea new case, continue on probation with safety placement on domestic violence case.
What is the date for that one?
Carla, if you have that individual case summary handy, can you provide it to Mr. Vandenberg and Mr. Morales?
Yeah, my notes don't show that, so.
Okay.
I'll send it to you again, Mr. Vandenberg. And I believe, Your Honor, that on the 27th, I'm gonna say it was Ms. Elizalde that was present.
Right. In any event, Mr. Morales, that might go a long way to, I don't know if you want to address this issue of possibly, does he even want you to continue to represent him? But if it helps that issue, then I just assume keep everything on track for now to see if we have.
Well, I don't want to derail anything, Judge, but at the same time, I think that I'm at the point where I've advised Mr. Hernandez about as much as I can. He just needs to make a decision on what he wants to do. So if we can get a clear offer from the state, I'll present it to him, and then he can decide what he wants to do.
Okay. So Mr. Vandenberg, Carla's going to send you the case summary so you can re-review it. Maybe you can consult with Ms. Elizalde. I know she's out right now, and just confirm for Mr. Morales by the end of day tomorrow if that 3 TDC is an option. And if there's the probation office option, just make sure those are clearly presented to Mr. Morales so he can communicate that directly to his client.
Will do.
I'm going to leave the settings, Mr. Morales. I would like to put that July 18 final hearing plea deadline to the 3 p.m. setting. So we'll move that to 3 p.m.
All right, Judge. I'll make a note of that.
Okay, so that way we'll be at the jail docket and we can see your client. Let me tell you, if you all have something that's agreed to and want to send it over to the court, happy to look at it. And maybe that 18th setting ends up being something else. Okay. Mr. Hernandez, your attorney is going to get some clarification from the state, and we will be back on the 18th.
Thank you, Your Honor.
Thank you. Thank you, Mr. Morales. Who's next?
Bottom of
Judge.
page 25.
Take care.
Annex, may we have Christian?
All right. Let me know if you have questions, David. This is a long, torturous one. Okay.
Yeah.
Thanks. Thanks, Judge.
Take care, Mr. Morales. All right, Mr. Huffman, is this yours?
Yes, yes, Your Honor.
Go ahead.
In cause number 2023-0D03155 and 2023-0D00951, State of Texas versus Sylvia Patricia Tristian. Announcement of council, please.
David Vandenberg on behalf of the state, and the state is ready.
Rick Huffman on behalf of Miss Tristan, we are ready.
And Ms. Tristan is appearing remotely from the jail annex. We are set for bond hearings in these cases. Mr. Huffman, you may proceed.
Thank you, Your Honor. Your Honor, we are respectfully requesting a bond reduction on the court to possibly consider reinstating her previous bond and granting a PR bond in the new burglary of habitation case. Ms. Tristan is 41 years old. She's resides in El Paso, and she's lived in the area pretty much her whole life. She does, from what I can tell, has no prior convictions. All the most recent.
Huffman, would you please back up so you can not be so muffled?
I'm sorry?
Just back up so you're not so muffled, okay? Please, thank you.
Oh, okay. Is that better?
Go ahead, Mr. Huffman.
So if she's released, Judge, she would go reside, and she lives by herself. She lives at 6017 Midas. That's in El Paso, 79924. She's considering, if released, employment as a server or in the restaurant field. Judge, she was out on PR bond, and I think the problem started with the misdemeanor court. I think there was an issue where she was supposed to come to court, and it was an in-person hearing, and she had missed. And I believe it was because there were some anxiety issues. But before then, she was appearing at court and had contact with me. I'm not sure why she missed. But as I was saying, Judge, there's not much criminal history here. And I don't think she's had any convictions prior to all of these latest arrests.
So let me ask, what are her ties to the community? Because I'm looking at her PSR, and she's got El Paso County 2008. That's just like a driver's license. And then she's in Dallas resisting Mesquite PD DWI, Dallas AFV in 2017. Dallas, another domestic violence in 2018, criminal mischief. I think we come back to El Paso at that point in 2021. So has she been in El Paso long?
You know what? I'm showing that she does, but now that I think about it, I think she's from Dallas, and I think she's been here for 3 years. Can I ask Miss
Tristan?
Miss Tristan, are you from El Paso? Where?
Yes, I was raised in El Paso. I was in Dallas for 12 years, and I've been back for 4 years.
Okay, but your family still lives in Dallas, correct?
My children only,
Okay.
but I don't. Basically, I was raised in El Paso all my life, but I was born in Mexico, so most of my family is in Mexico.
So you do not have family here in El Paso?
Only my uncle Jimmy Smith.
Jimmy Smith is your uncle?
Yes.
That's the
Yes.
gentleman, Judge, that's really, it seems to be really her only support system, but he is involved, and he's been calling me, and that's actually whose house this is on Midas.
Okay. What else?
Well, it looks like everything's filed, Judge. I would imagine that these cases are probation type cases. And we're asking the court to consider letting her out again and giving her a chance to get on the right track so that she can start her probation on the right track.
All right, anything else?
No,
Mr. Vandenberg?
Well, Your Honor, the state objects to a reduction in bond. You yourself pointed out the number of cases from Dallas County that Ms. Tristan has accrued criminal mischief. Two other things, which are El Paso cases. She has recently acquired two misdemeanor, actually not misdemeanor cases. Back into here. He files, one for criminal mischief of $750 to $2,500 and one for criminal trespass. These are, again, very recent cases, so there's not much in here. Offense date of the criminal trespass is November 17th, 2022. And the burglary of habitations that we have, one in 2023 to 3155, the offense date is just May 30th, 2023. So Ms. Tristan has come back and has started to reoffend here. The state is concerned that if she's released, she will keep on offending, doing more burglaries. She has a record that seems it's not as strong or as substantial as other people, but there is a regularity to her conduct here, Your Honor, that the state is concerned about. And in the last 6 to 9 months, there's been a splurge of activity related to criminal offenses. So we would ask that for the good of the community and the safety of the community, bond not be reduced, Your Honor.
I'm sorry, Mr. Huffman, you did say anywhere from 1,000 to 1,500, maybe. Is that right?
She's got, well, actually, I don't believe I've asked that question to Mr. Smith. But any relief would be welcome, Judge.
Yeah, I'm not so sure that in terms of, it looks like she's got, there are $100,000 bonds there because those are, she wasn't compliant with PR bond. And so as to cause number, I think I'm missing a cause number, but it's 951. Yeah, 00951. I'll reduce that to 50,000. But the remaining bonds are appropriate. And so, yeah, I think the 951 is the highest one. It's showing as a detainer. Let me ask the clerk. It has a commitment sentence detainer, 100,000, and then the PR revel, 100,000. Ms. Melendez, can you tell me a little bit about that? Because I think that's what's got her so high, and it's the same case.
For the
951. Mm-hmm.
It is the warrant was actually for 100,000. That's all that I'm showing for that one. So she is being held on that one for 100,000.
So, but her total bonds are 200. There's two $100,000 bonds.
Yes, Judge. So the 3155 is also at 100.
Oh, is it? Okay, I'm only seeing 40,000 there. Okay, so on 951, it will be, actually, it will go down to 40,000 cash surety. The 3155 will be 40,000 cash surety. That's it. That's what we have. Okay, Mr. Huffman.
Yes, Your Honor.
All righty. Thank you very much.